So my topic for today is in an Austro-Libertarian view of intellectual property rights. I'll start off with a short introduction. Basically, when we talk about intellectual property rights, what it means is, or some kind of a definition that we could give to intellectual property is property in ideal objects, which are instantiated in physical, tangible objects. So because ideas do not simply float around and they are inaccessible so long as they remain exclusively in the mental realms of individuals, they are necessarily expressed as instantiations, as incarnations in physical, tangible objects. The question then arises if such instantiations are to be considered the exclusive property of the creator, discoverer of the ideal object, which is so embodied. The critique of IP in the Austro-Libertarian tradition is basically centered around the theory of property rights, which was developed by the American economist and political philosopher Murray Rothbard, and continued by another professor, Hans Hermann Hoppe, who is also an Austrian libertarian economist and political philosopher. The contention basically is that the two main arguments that are being proposed for intellectual property rights, which are the natural rights argument and the utilitarian argument, are basically invalid and are untenable. So this is what I'm going to try to prove during my presentation based on the resources provided by the Austro-Libertarian tradition. So to get to the next slide, first of all, we need to understand what intellectual property is, or IP. And as stated above, IP is a property in ideal objects as expressed or embodied in physical things. And Stefan Kinsella, which is also a libertarian thinker, identifies at least 4 types of IP typically included in legal systems around the world, which are copyrights, patents, trademarks, and trade secrets. So given the audience today, I'm not going to go into the details of what each of them mean. I presume that these things are already known. So I'm just going to skip to the next slide. Now, as far as the arguments for and against IP go, as within the general academic population, so too within the libertarian academic environments, there are varying views with regards to intellectual property, ranging from most extreme and extensive rights to complete dismissal. With regard to the general debate, in 1958, Fritz Mackolp submitted a review of the patent system to the American Congress, where he identified 4 positions on which the IP advocates have rested their case. The first of which is the natural rights argument, which recognizes the property right of an individual in his ideas and rejects any unauthorized use thereof. The second would be the reward by monopoly argument, which states simply that each individual must receive due compensation for the services rendered unto society. The third one is the monopoly profit incentive thesis, according to which the cost of developing inventions is so great that on the whole, no entrepreneur or group of entrepreneurs would ever embark on the journey to new discoveries absent the guarantee that their fixed costs would be paid off by some kind of way by society. And let me just make a short comment here. I'm saying fixed costs because creation costs, I mean the development of a new idea, are in the long run fixed costs because given free competition, the prices of newly developed goods tend to be equal to the marginal variable costs, such that the initial developing costs are not really covered by the price, or so the theory goes. The fourth and final argument for IP is the exchange for secrets position, which argues that the monopoly grant is simply society's way of trading privileges for secret knowledge, which would not have been disclosed otherwise. This is because when the patent expires, the invention enters the public domain. But for the purpose of my presentation today, I will just classify all those arguments into 2 categories. which is the natural rights argument and the utilitarian argument. The first type of argument, which is the natural rights argument, consists of the principal rights-based arguments. Thinkers fall under this heading, who fall under this heading, try to identify certain fundamental principles which serve as the basis for claiming property rights in intellectual creations. And the physical instantiations of those creations. Non-utilitarian libertarians and liberal thinkers, by liberal I mean classical liberal thinkers that support IP, would include Ayn Rand, Gallenbos, Lysander Spooner, and Herbert Spencer. The second category consists of utilitarian arguments in favor of IP. And more often than not, they revolve around the idea that progress is desirable, and by progress, it is typically understood technological progress. However, the costs, especially in our highly developed economies of small increments in innovation, are on the whole prohibitive, and unless society steps in through governmental intervention, to grant privileges to inventors, the whole process will come to a halt, and we would be condemned to a perpetual suboptimal state of development. Now, I would go to my next slide, and I will try to first of all elucidate the problem of the natural rights argument. So, in order to understand where the supporters of IP as a right go amiss, we must take a few steps back and consider what property is and how property rights come about. So according to the Rothbard-Hoppe paradigm, the source of property rights are to be found in the idea of self-ownership coupled with the empirical fact of scarcity. In a state of superabundance, where resources are not scarce, interpersonal conflicts would not arise, since the control and use of a resource by one individual would not diminish the available stock for the rest of the population. However, the fundamental characteristics of the physical world which we inhabit is that of scarcity. Natural resources and a fortiori economic goods are never in such abundance as to exclude competitive and conflictual uses for different purposes. Consequently, there emerges a need to have exclusive rights to resources allocated in such a way as to avoid conflict and to foster human cooperation. In the state of nature, which one might characterize as a condition in which property rights are not recognized or respected, might makes right, which means that whosoever is able to take by force an owned or unowned resource may be able to keep it until they face a mightier rival. And just to quote from Hans Hermann Hoppe here, he says that only because scarcity exists and is there even a problem of formulating moral laws. Insofar as goods are superabundant, which by that we mean free goods, no conflict over the use of goods is possible and no action coordination is needed. Hence, it follows that any ethic correctly conceived must be formulated as a theory of property or as the theory of the assignment of exclusive control over scarce means, because only then does it become possible to avoid otherwise inescapable and unresolvable conflict. Alternatively, we can quote also from Benjamin Tucker, who says that if it were possible, and if it had always been possible for an unlimited number of individuals to use to an unlimited extent and in an unlimited number of places the same concrete things at the same time, there would never have been such a thing as an institution of property. Now, the only logically possible rule of appropriation that does not lead to absurd consequences and does not contradict the axioms of self-ownership is the finder's keeper's rule. That is to say, any unowned or free resource may be homesteaded by the first person to occupy it and to put it to use. Moreover, any good that is obtained by voluntary exchange from a rightful owner also constitutes legitimate property, and that is the title transfer theory of contracts, which basically says that what is exchanged are not goods, but property titles to goods. Now, going back to analyze the claim that IP is justified and that a creator of a new idea is entitled to control over physical expressions regardless of whom owns those physical goods, we may see that two issues immediately arise. So first of all, it becomes apparent that ideas are just are just such things that can be used to an unlimited extent and in an unlimited number of places by an unlimited number of individuals without the slightest lessening of the ability of the original creator to enjoy his idea. That is to say, such recipes are, as a rule, free goods, as their ability to produce definite effects is unlimited. They can become economic goods only if they are monopolized and their use restricted. Ideas and inventions are not scarce. Once the inventor or creator puts out the idea, it becomes a free good in the sense that it cannot be exhausted by increased use. Secondly, IP rights grant creators partial ownership or partial property rights in the resources owned by other individuals. For example, if A creates a new mousetrap and patents it, all other individuals are prohibited to use their own resources legitimately appropriated to recreate the pattern and functionality of the patented object. This, of course, means that to a certain extent, the patentee partially expropriates the legitimate owners of their own property. Note that the argument being proposed here is not that individuals have an absolute right to use their property in whichever way. Libertarians acknowledge that limitations to use of one's property begin where encroachments or trespasses onto others' property occur. That is to say, I'm not free to shoot a gun, for example, from my land lot at the neighbor's house, nor am I free, for example, to pollute my neighbor with toxic fumes resulted from the activity I undertake on my legitimately owned property. However, an aggression has yet to be proven in the case of IP. Using an idea in conjunction with legitimately owned resources does not in any way aggress against the inventor and his property. There seems to be a misconception that the creator or the inventor is entitled to the fruits of his labor that encompass all physical externalities of their idea. However, this is not the case. Only those externalities belong to him that derive from material goods he owned before or from free goods appropriated. In particular, he is not the owner of the material goods owned by others. Hence, the owner of an apple pie recipe, for example, remains the owner of his idea, but he cannot claim the sovereignty over the ingredients owned by housewives. Now, to go to the slide here, the 8th slide that I have, this is my second main argument, which is a Rothbardian case against the utilitarian argument for IP. So I'll go through it as fast as possible because I believe I'm approaching the end of my allocated time. So basically,
Mr. Tanasuica, your time can be extended as the next speaker also has some technical issues, so there's no need to speed up.
Okay, then I'll just talk slower. Thank you. As I was saying, my second argument is addressed to the utilitarian case for IP. And just to summarize what the utilitarian argument is, it's basically the idea that the end of encouraging more innovation and creativity justifies the seemingly immoral means of restricting the freedom of individuals to use their physical property as they see fit. Before we attempt to rebut this position, however, we must first review a few theoretical aspects of utility theory and welfare economics. One of the pervasive claims of utilitarians has been that policy prescriptions can be made on a vertebrae that is value-free basis simply by recommending those measures which, at least pro forma, seem to maximize social utility or alternatively minimize social cost. And Fritz Mackel, which I mentioned earlier, goes into more detail as to what each of these concepts mean, especially in the context of intellectual property. This is the case, for instance, with the neoclassical justification for progressive taxation, which was provided by A.C. Pigou, which probably you're familiar with. What they're saying is basically, since economics establishes that the marginal utility of money decreases as money incomes go up, we can deduce that $1 has a lower marginal utility for a rich man than it has for a poor man. And hence, ceteris paribus, a progressive tax that takes from the rich and gives to the poor maximizes social utility. The problem is that this type of argumentation is basically invalid, as Lionel Robbins showed, because it utilizes interpersonal comparisons of utility. So the Austrian school of economics in the Menger-Mises tradition established the fact that utility is simply the importance rank given to a want that could be satisfied by a good. This means that utility is an ordinal value pointing to a place on a hierarchy of wants and is not in any way subjected to arithmetical manipulations. As such, any attempts to compare the utility between two individuals or even to determine relationships between different goods on the value scale of the same individuals, for instance, to say that a person X prefers an apple twice as much as he prefers a pear, are inconsistent and futile. The conclusion that value judgments are inescapable and that utilitarianism cannot be fashioned into a value-free policy selection tool does not amount to the end of welfare economics. Rothbard attempts to reestablish welfare economics on firm foundations that are consistent with the subjective theory of value. Basically what he does is that in his seminal article, which is called Toward a Reconstruction of Utility and Welfare Economics, Rothbard proposes two concepts for a policy assessment that allow a value-free determination of whether a certain intervention leads to an increase in social utility. Naturally, the goal of increasing utility cannot be justified from within economic science because economic science is a value-free science as all other sciences, and must be taken as a given from outside this science. Now, social utility in the Rothbardian sense must be understood as the collection of individual utilities for a group of people or for society as a whole. It is typical of the Austrian tradition that they do not operate with holistic concepts. Following the methodology of praxeological inquiry, logical deduction, and methodological individualism, we understand that only individual act bear costs or enjoy utility. Hence, it is meaningless to speak of social costs or social utility in an aggregate manner as distinct from the simple collection of individual scales of preferences. The two concepts proposed by Rothbard to analyze policy proposals are drawing on, and of course he is drawing on his intellectual predecessors, are the Pareto unanimity rule, or the Pareto-Robbins unanimity rule as Rothbard terms it, and demonstrated preference. The Pareto rule simply states that we can only say that social welfare or better social utility has increased due to a change if no individual is worse off because of that change and at least one is better off. If one individual is worse off, the fact that interpersonal utilities cannot be added or subtracted prevents economics from saying anything about social utility or how it's being modified by the proposed change. Now, the concept of demonstrated preference simply states that actual choice reveals or demonstrates a man's preference. That is, that his preferences are deducible from what he has chosen in action. We can only glimpse at what an individual prefers by observing his exchanges on the market. As Mises put it, action is preferring and setting aside. By observing what an individual prefers and what he sets aside, we can deduce what was ranked higher on his value scale. Now, it is important to emphasize that demonstrated preference is discoverable only through action. It will not do to submit an individual to a questionnaire, for example, so that his preferences are revealed, whereby a model should be constructed out of the data. To illustrate a point in connection to the IP debate, it will not suffice to simply ask people if they prefer more innovation to less innovation, and then to proceed to conclude that therefore monopolies are thereby justified. Or to put it another way, the objection, but who is going to produce more music if one can simply copy a song and put his name on it, does not reveal preference for or the intention to support copyrights and forfeit partial property rights on owned resources. The key to demonstrated preferences are voluntary interactions and exchanges on the free market, and only insofar as an exchange has not been coerced and can we conclude that an individual acted out his preferences. Now, going back to examine the utilitarian case for IP, we immediately notice its problematic nature. We must not stop ourselves at remarking that because it presupposes an interpersonal comparison of utility, therefore we cannot say anything about the way it affects social welfare. Based on the concept of unanimity and demonstrated preference, we can conclude that IP rights in the form of monopoly privileges, or basically any form that is not voluntary and contractual in nature, should be rejected as conducive to a diminished social utility. The only way to salvage IP in my perspective at least, as a legitimate form of property, is to put forward a solid natural rights case. That is, until such time as IP supporters can reasonably prove that inventors and creators can justly claim partial ownership of everyone else's property and prohibit them from using it as they see fit, IP should be considered as illegitimate. Now to my concluding remarks, first of all, I'd like to say that libertarians in general are not against progress and innovation. They are also not against respecting creators and inventors. However, a clear distinction must be made between moral maxims, which say that we need to encourage inventions and creativity, and legal rights and obligations. While it may not be justified to grant IP rights to individuals, there are still voluntary free market alternatives that can be explored to secure some sort of reasonable protection for intellectual creations. Moreover, there is evidence, and there's quite an extensive literature, that IP is oftentimes detrimental to the diffusion of innovations in society. And for what it's worth, we are unaware of any study today that any studies that have demonstrated that IP improves the social bottom line. Quite to the contrary, there's also a book that I recommend here against intellectual monopoly. Many authors demonstrate that IP is quite detrimental to innovation and to dissemination of innovation in society. At any rate, we must conclude that if individuals fail to compensate creators, innovators, and any other entrepreneur to a satisfying degree based on their own preference scales, we are only seeing the demonstrated preference playing out, and at least on utilitarian grounds, we cannot conclude that this is somehow bad for society. Like with any other good, the optimal amount of innovation and progress is that which is the resultant of voluntary associations and exchanges, and any other amount set forth as better or optimal than what is naturally obtained on the market must be regarded as more or less arbitrary. With that, I conclude my presentation. I hope it's not too shocking given the audience today. And thank you very much for, thank you everyone for participating, and again to the organizers. Yeah, thank you.